Well, good day, everyone, and welcome to another edition of Q&A Social Security Disability Today. I am your host, Anthony Reeves, attorney at law, and it's a pleasure to have you with me this fine and beautiful day. I know I've gotten a number of questions over the last couple of weeks. My apologies for not giving you a broadcast last week, but you know what? We're going to keep this thing rocking and rolling. As always, if you want to subscribe to my blog, legalbeat.anthonyreeves.com, just to make sure that you're aware that I cover other topics related to Social Security on my blog that I don't cover here as part of my question and answer. So you definitely want to check that out. As always, you can check me out at www.reevesfirm.com, which also provides a free claim evaluation. If you fill out the information, it's routed to my firm and then it's forwarded to me so I have the opportunity to review the information and give you some feedback if you need it. Also, as always, you know, if you want to email me, it's anthony@reevesfirm.com. Great place to start. And as always, let's make this thing do what it do. All right. First question today has to deal with something that I haven't had come up very often. They asked, what kind of legal action can I use to protect my financial income from being garnished by SSA because they claim they made some overpayments after my disability had already ended? And it's interesting because it's actually a two-parter because they said what kind of legal action it can take to make an investigation into ACA for running some kind of money scam. Here's the thing that people fail to realize. When you're applying for disability benefits, you are participating in a federally run program. That means this is federal money. You're putting money into it, but it's a federal run program. And so they have a duty to ensure that you're only receiving the monies that you are legally entitled to receive. Let me make one point abundantly clear. There is no scam with the federal government when it comes to federal money. So I say that not to be disrespectful in any way, shape, or form. It's sometimes what happens when people get hit with overpayment, they get angry. And let's be real. Anytime people get hit with an overpayment and you get an invoice or a letter saying you owe two, three, four, $5,000, and that's usually how it comes down, you get hot because your first thought is, it's your fault that you paid me too much, so why should I be penalized for it? And that is a awesome and valid point. But I want to make one point abundantly clear. There is no scam here. They're basically saying they gave you money you should not have received and they want it back. It'd be different if they say they gave you money and it was yours legally and they try to take it back from you by some illegal means. So it's important to understand there is no scam here. It's a situation where they have made a determination that there was an error in the amount of money that you received. Now, how do you protect yourself? Well, here's where it becomes weird. A couple things you need to keep in mind. First, there are provisions within the regulations that allows you to ask for what we call a waiver. And what you do is you basically tell the government either one of two things. One, the fault that they made was completely 100% their fault, and that you took all actions to prevent them from creating that fault, and that they should excuse that error so that you're not penalized for it. Or you can do what we call a hardship waiver. A hardship waiver is where you're basically saying that if you try to take the money back from me, you're going to devastate me financially more so than I am already. As such, we're asking for that money to be waived as a result of that. You're actually going through the same process as if you would go through the disability process, i.e., if they send it to you, you can appeal it. And if they make a determination, you can appeal that again. You can exhaust all of your administrative appeals and then sue in federal court if necessary. I've never run across anybody who's ever done that, so I don't know if the regulation prohibits you from being able to do that. So I don't want anybody thinking, I'm going to go and sue the Social Security Administration, and after exhausting your remedies, you may not be able to do that. But for purposes of remedies, you can ask for a waiver, and typically those waivers can either be just a regular waiver, basically saying it's all your fault, or a hardship waiver. It's wild because most people who fall into the overpayment situation usually happens under such weird situations. Either they told Social Security that they've gone back to work, and Social Security, for whatever reason, kept paying them. They've something happened, and maybe they got an extra month or two or beyond that they shouldn't have got because Social Security system didn't catch the pay, and then when they did catch it, they had paid them too much. Invariably, it's a two-pronged thing, and this is something, and I know people, if you're listening to this, you're not gonna like what I'm about to say. Because I always tell people, invariably, most people who get an overpayment, you know already. And this is not trying to be rude, but let's kind of call it like it is. If you tell Social Security that you went back to work on January 1st and you're still getting monthly benefits from Social Security, you need to be telling them that you're still getting those benefits. What happens is that people go back to work, they keep getting those benefits, and they're thinking, oh, Social Security, I've heard it before. They say the government knows what they're doing, so obviously I'm entitled to the money, so I just keep receiving it. And what do? They go ahead and they take advantage of receiving it, and then when the overpayment comes, they get upset. Or maybe Social Security said we're going to end your payments on June of this year, and then into December you're still getting benefits. Now, here's the thing, again, that's fascinating. You already know they told you that your benefits are due to end on this date. Yet and still, you're still getting benefits. Have you told them that you're still getting it? Most times people aren't. They don't say anything. They just keep enjoying the benefits. It's when the benefits come and they get the letter saying we shouldn't have paid you all that everybody wants to start bringing ruckus. Bear in mind, because typically they're going to ask the question, what did you do to let Social Security know that there was an error? So in this instance, if they said that your benefits were due to end in January, yet we're into June and you're still getting benefits, have you told them? And most people say, oh yeah, I told them. When? Well, I told them in February, but did you tell them in March? No. April? No. June? No. May? June? So basically 4 months went by, you were still getting them and you only told them back in February. But you want to clown. Okay, I'm throwing this out here and I'm playing devil's advocate because that's how they're going to look at it. Are there times when Social Security makes errors, whether it be computer errors and things like this happen? Absolutely. But the beauty of the federal government is that they have revenue, they have remedies to get their money back. You need to be smart. If you know that a circumstance has created itself where you should not be receiving benefits, maybe you're receiving benefits on behalf of somebody and that person is in jail. Maybe you went back to work. Maybe Social Security told you you're no longer entitled to receive those things. If those things have kicked in, you have been put on notice. Now you have to ask yourself, if you haven't been put on notice, that's something different. That's why you need to ask all these litany of questions. If they're saying they overpaid you, how do you know this? Well, did they say they told you that they said they could cut your benefits off? Were you aware that they cut your benefits off? Were you aware that you were still getting benefits even though they told you they cut your benefits off? When they cut your benefits off and you knew this, did you put the money to the side so that you would have it to give back to them? No. Most people do none of those things. And then what happens is that when you get that lovely notice from Social Security telling you owe money, you want to clown. And I'm telling you, I understand. And trust me when I tell you, there's a lot of representatives, attorneys and non-attorneys who work with people who are in the situation of helping people with overpayments. So you can beat an overpayment. So I don't want anybody to think I'm saying that when you get it, you got to just sit there and like it. You can fight it. But I just tell you, be mindful of what role you played in that overpayment coming against you. Because that's how they're going to look at it as well. All right, so let's go down to my third question here. Person told me they've got a hearing, they just had a hearing back in May. And they basically said that the decision was mailed out. It's been about a month and a half. And they're kind of curious to know if the decision coming out being a good thing or a bad thing. Let me make one point 100% clear. Time has no relevance to whether you get a favorable or an unfavorable decision. Listen to the words that are coming out of my mouth. Time means nothing. Okay? I have a judge that I've gone before. 2 judges, as a matter of fact, in Orlando area, great judges. And they literally, when they make decisions on the bench, they'll get the decision out to you in a week. Had another judge in the National Hearing Center, same way. He made a decision on Monday. I had that bad boy by Friday. Awesome. I know a judge down in another part of the state. When that judge renders a decision, a denial, you get that denial in the same week. So guess what I tell people? Don't ever base your expectation of a favorable or unfavorable decision on the time. I have another judge, it typically takes him 4 to 6 months to get a decision. And typically, you don't know which way he's going to go. And he uses the full 6 months. And so it's 6 months later and you could get denied. 6 months later, you get approved. Now, fortunately, Social Security has been putting a hamper on judges doing those type of things. But this was a few years back I had this one with this judge. So I tell people, please never rely on the time it takes for you to get your decision as an indicator of whether or not you're getting approved or disapproved. All right, final question. 31-year-old young lady who's relapsing from remitting multiple sclerosis for the last 6 years. Her condition is progressive, and so she's wondering about whether or not the role is going to have her and her being disabled, and is she too young? I typically tell people that the regulations tend to be more favorable to you if you're 50 years or older, but that does not mean that you cannot be found disabled if you're younger than 50. The regulations allow disability from the date of conception, of birth, all the way to the date of retirement. So you can be found disabled at any point in time. The focus when you're a younger individual is, remember, Social Security's vibe is, you remember, between 18 and 49, those are your golden work years. So the presumption is that if you're under the age of 50, you should be able to acclimate to another job a lot easier than if you're a little bit older. Not saying that older workers can't, but the presumption is that a younger worker can. So your focus should not be so much on your age, even though it does play a relevant part. Your focus needs to primarily be is how limiting is your condition. Is your condition limiting to the point where you're not able to do a simple sit down job? Sit down job where with very very minimal interaction with the public, because there's a few jobs out there that are like that where you can sit, all you have to do is maybe look at something like a system surveillance monitor, some assembly line work. There are some cashier's jobs where sit down. The key is, can you do a sedentary job when you're under the age of 50? That's really the biggest question. If you don't meet the listings, meaning you don't meet the express criteria of any medical condition, your then question then becomes, can you do a sedentary job? A sedentary job is a job that it requires no more lifting, either frequently or occasionally 10 pounds, if I remember correctly. It requires you to sit 6 out of an 8 hour day, stand and walk 2 out of an 8 hour day, with the standard 15-minute breaks in the morning, 15 in the afternoon, and 30 minutes for lunch. If you can do a job like that, and especially if you're under the age of 50, then you're going to probably have a tougher time being found disabled if you don't meet the listings. So keep those thoughts in the back of your mind when you're trying to decide. And actually, that's a good point. When you're a younger individual, remember, Social Security is, their presumption is that you're in a much better position to acclimate yourself to the work environment in terms of finding another job. So keep those things in mind. All right, everybody. Again, I want to thank you for joining me for another episode, another edition of Q&A Social Security Disability Today. I am your host, Anthony Reeves, attorney at law. Keep those questions coming, and as always, look forward to seeing you here again next week. Take care.